everything you need to know about products and services that can improve your life. This is Experts on Call on CIL 650.
Welcome back. This is CIL 650's Talk About Strata, and we have Adrian Murray and Shannon Salter in the studio with us tonight. Very pleased to have you both here because we're talking about the way it is right now with Adrian with respects to how you enforce bylaws, how you deal with the law, and the way it's about to become with Shannon Salter, who is the chair of the tribunal, and the transformations that are going to happen with strata disputes. We left off, we were talking about hardship, and we were talking about the scenario where a strata knows a person doesn't have money to be able to challenge them when they deny a hardship application. So frequently they do, even though they're not supposed to. They're supposed to act reasonably. But the bigger challenge then is, what about somebody who makes an application and then they disagree with the decision of the Strata Council? As we're dealing with it now, Adrian, what's the transformation, or what are their options right now?
Well, today I think they can reapply. I mean, perhaps the decision was made by the council quite legitimately because there wasn't enough information provided that supported a hardship application. So it's not unreasonable for the owner, and at that point, even maybe getting a little bit of legal advice might be helpful. There are a lot of people who believe that simply making the request should be sufficient. If I've told you that I have hardship, that should be enough for you. And the courts are clear that that's not sufficient, that you need to provide some evidence that this causes hardship to the individual. So the individual then may want to reapply and provide all of the detail as to why this is hardship, what the circumstances are, and that includes, I think, both the reason, the financial information, which people have a hard time conveying. I mean, it's very difficult to start laying out your tax returns and your visa bills and everything else and your mortgage payments to show that what kind of financial state you're in, and some reason why I can't live in this unit. One of the reasons may be I simply can't afford the special levy that's come along. So there may be, in addition to just kind of keeping my head above water, which I may just be doing, I may be facing a payment for a special levy. I may have to move home with mom and dad and live in their basement for free while I rent out my unit in order to get us through this difficult position. So there's all sorts of things, but all of that compiles into what the strata must consider. At the end of that, you make the application, you give them all the information you can, and you rely on the strata to make a reasonable decision, which they may or may not do.
Well, and not to lay this all on the strata as being bad people and the owners being the ones who are always the innocent victims here, but we also have individuals who want to rent their unit out and buy a unit somewhere else and keep this as a investment unit now, and then the bylaws don't permit that.
Absolutely,
right?
absolutely. Yeah, retaining it as a rental unit because even the market has dropped and I may not make as much money. That's not necessarily hardship. So, you know, it's subjective, absolutely subjective, but there's certain circumstances I think the majority of the population would view as not being a hardship. You've put yourself into that position by choosing to buy another property.
So we've had hearings, we've gone through the approach. Council still says no. I still think I have a reasonable hardship exemption. My only real option would be to do what now?
Today, make a court application.
Court application.
And the court application has to be made in BC Supreme Court. This isn't a small claims issue.
Yep.
So we're off to BC Supreme Court to make an argument before a judge that the council has acted unreasonably and has not fully considered my hardship application, and that in fact I am suffering from hardship.
Which is counterintuitive to the cost that's going to be associated with the Supreme Court application, which is why most people simply don't make an application because they can't afford it in the first place if it really is a genuine hardship.
That's obviously part of the issue. Other people, I mean, you sometimes by this stage, don't forget time's gone by. So if in fact I'm not living in the unit or I've been forced to go someplace else, I may just be in a situation where I've decided that it's just easier to allow foreclosure, bankruptcy, or I've put the unit up for sale and just given up.
So Shannon, tribunal, what do you see the transformation in this type of decision?
Well, I think for somebody in that situation, the tribunal is going to be very, very helpful in terms of being able to get a decision that's binding very quickly. So assuming somebody's gone through that whole process, they've exhausted their internal remedies, requesting a hearing, and that's something that oftentimes people don't remember that they can do, that there are some avenues today under the Act that they can use to try and resolve their dispute with the strata corporation, including the hearing process. But assuming they've done all of that and it still hasn't been successful in their view, then what the tribunal would do would let them start a tribunal claim and know that 60 days later, roughly speaking, they would have a binding decision. They wouldn't be stuck in a court process that could drag on for months or years. And they also know that it wouldn't add to their financial burden, because in addition to the fact that for a regular participant, the cost of the tribunal will be roughly what small claims costs right now, which is about a couple of $100 once you add in all the bits of paper. That's roughly what the tribunal will charge as well. But for people who have financial hardship, they can get an exemption, so that they wouldn't even pay that amount. So what the tribunal will offer is a way to quickly get a binding decision, inexpensively or for free, depending on their financial circumstances.
So tribunal is going to provide more accountability for strata corporations, more accessibility for owners, and this has quite an impact on the day-to-day function. So, let's just turn it a little wee bit more now, and let's talk about bylaws and the enforceability of bylaws. So I've made a hardship application, but now we have some serious issues around whether this bylaw is enforceable or not. And so, traditionally, if we wanted to challenge the enforceability of the bylaw, Adrienne, it still was a Supreme Court application.
Absolutely. Mm-hmm.
And so there's all the cost and everything associated. That's another jurisdictional transition, though, isn't it? That is now going to be in the Civil Resolution Tribunal.
Yeah, that's right. So the interpretation of bylaws, the interpretation of the Act and regulations, all of that is within the jurisdiction of the Civil Resolution Tribunal.
So it's going to be, it's in a default way, I've said this a few times, but in a default way, the tribunal is kind of becoming the regulator of the Strata Property Act. It is a, by virtue of decisions, by virtue of a place that you have to go with respects to whether a bylaw is in fact enforceable. Rental bylaws, for example. A good example of rental bylaws that we have challenges with are how they're counted. How are rentals counted in buildings? And so, a strata has a bylaw that permits 5 rentals at any time. What does that mean?
Well, and the Act now helps us out to understand that there will automatically be people who are permitted to rent. I can always rent to a family member, and I can always rent if I have the benefit of a rental disclosure statement. I'm the first purchaser from the developer, or it's after 2010 and I have the benefit of the rental disclosure statement. Those aren't counted in the number.
Right.
The Act makes it clear. So essentially it's clear. However, we have seen stratas that aren't willing to take that view. Again, with this idea of trying to limit rentals to the absolute minimum, refusing to permit those to be excluded from the count.
It's an interesting, you've said that statement twice now, that strata corporations just don't want rentals. They're afraid of what they might have if they allow rentals in their building and what the impact are. But my experience over the years has taught me that whether there are rentals in a building or not has virtually no implication on how a building functions. Oftentimes the buildings, it's how the strata actually administers and runs the building, how they enforce bylaws, how they communicate with the owners. Tenancies, you can have problem tenancies, but you can also have problem owners that live in buildings that create just as much difficulty.
Oh, absolutely. I think the difference, though, with a tenanted building is that your non-resident owners sometimes don't have the same desire to see the upgrades and the refurbishment. When it's a business for me and I'm looking at return on investment, I don't really care whether the lobby is peach or green. And if it's green and it's out of style, that's not going to impact the rent that I can get on my unit. So I'm maybe less inclined to approve those types of resolutions. And I think on the one hand, there's issues with the conduct of tenants and owners, and I absolutely agree with you. There's as many problem owners as there are tenants. In fact, maybe even more, because they know they cannot be evicted or with extreme difficulty. The other hand, I think, though, and the other concern that stratas have is the lack of sense of we all live here, we all belong, we all cooperate, we want to refurbish our buildings, we want to keep them up. And sometimes non-resident owners don't share that same view. So I understand the concerns.
Yeah.
And rental prohibitions are certainly possible, but they need to be done properly. So, this is, in my view, isn't an issue about whether we should have or should not have rental prohibitions or restrictions. The Act permits them. My issue is they need to be enforced. The bylaw needs to be enforceable, and the bylaw needs to be enforced fairly and appropriately.
Under the tribunal, Shannon, we have the tribunal will have the ability to determine whether a bylaw is enforceable or not. So, and that applies with any other enactment of law. So, how do you envision a decision of adjudicators to look with respects to that enforceability? And then of course, there are going to be all the complications of how it's applied after it's determined whether it's enforceable or not.
Right, and so that leads to a bit of an explanation about who these tribunal members are. They haven't been appointed yet, but we expect them to be appointed very soon, or at least for the first round of them to be appointed. And there's likely to be two divisions, so a strata division and a small claims division. And that lets us establish a pool of expertise in the strata division, largely lawyers who have practiced extensively in strata, people who also maybe have arbitration or other adjudicative experience, bringing that experience and that expertise to bear when they look at the facts, they look at the evidence, and then they look at the law and apply it in a reasoned, sound way.
So I think strata corporations, as the tribunal starts to roll into effect, will start seeing more of a test on their bylaws, which raises the whole question that we have with stratas all the time. Who wrote your bylaws in the first place, right? Was it a volunteer? Did you steal them from another strata? It's one of the bad things that happens is strata corporations notoriously will get bylaws from other strata corporations and assume that they are enforceable or functional. And so I suspect we'll see quite a lot of challenges around the enforceability of bylaws.
Yeah, and I think you're alluding to another issue, which is that when you don't have the ability to test those frequently because the court process is too expensive or not viable, then you really limit the whole sector from establishing these best practices. We don't know what the limits are of enforceability. We don't know the parameters of that. And hopefully the tribunal over time will help stratas in understanding what those parameters are for enforceability.
Well, and Adrian, we actually haven't seen a lot of case law around whether a bylaw is enforceable or not.
There's not a lot of law.
No,
there's not a lot of, and again, because of the impractical mechanisms to challenge.
Right.
The whole concept of the strata property legislation is that it's based on a democratic process. And so I think a lot of people take the view that I might be upset with a bylaw, but I can't do anything about it because democratically it's been approved by a 3/4 vote. Now, I can tell you in many, many cases, the vast majority of owners have not read those bylaws. So they voted on them, but I heard of one yesterday that requires an owner to grant permission to enter a strata lot under certain circumstances. That's not surprising. But then the bylaw goes on to say, and if the owner does not grant permission, the strata corporation can enter and essentially break down the door. And the cost of the repair is the owner's. And this can be done to simply investigate whether a bylaw is breached. So I'm going to bet that in that strata, the vast majority of owners don't know that that bylaw exists. A couple of owners that are aware of it really haven't got the means to challenge it. So I think, yeah, that we don't have those challenges in court, but I agree, Shannon, that over time, the tribunal will give us the kinds of practices and the advice that we need in terms of enforcement. I think the other issue that from the flip side is that it's going to make bylaw enforcement on the part of the strata corporation much more feasible.
It will make it more feasible. It will make it more academic, I think. I think it'll be less personal related and it'll be more of a business decision of how stratas are methodically going through bylaw enforcement, how they're applying. One thing, then we'll go to a break, Shannon. Decisions by the adjudicators are not precedent setting, are they?
That's right. So like any other tribunal in BC or in Canada generally, decisions of one tribunal member are not binding on another tribunal member. However, decisions of the court, so the BC Supreme Court or the Court of Appeal or the Supreme Court of Canada, all of those are binding on the tribunal. The tribunal has to apply those court decisions in making their own decisions. That said, it's a best practice in tribunals to try and build a sense of cohesiveness among tribunal members in terms of their approaches to certain issues, although you can't what's called fetter the discretion of any one tribunal member. But we are looking at ways that we can make sure that the tribunal is as cohesive as possible in its decision making without interfering with that discretion that each tribunal member has.
And decisions that will come out of the tribunal will be posted eventually on the tribunal website, so people can look at them, see the nature of the dispute, what the decision was, what the implications were.
That's right. So decisions will be posted on the site, they'll be searchable, they'll be transparent. If somebody's curious about what the tribunal seems to generally do with pet disputes or parking disputes, they can look at the cases in those areas, and hopefully that will be helpful in helping them decide what their next steps are with their own particular dispute.
You're listening to QuayPacific's Talk About Strata on 650 Sea Isle, and we'll be back right after these messages.
This is Experts on Call on Sea Isle 650.